Kirsty Sutherland, thank you. I want to ask you right off the bat, what inspired you to become a defense lawyer in the field of international criminal law?
I grew up in countries that were very severely affected by war and sort of state breakdown, and in countries where it was not guaranteed that girl children would have access to an education. So I think I grew up acutely aware of the privileges extended to me by virtue of my nationality and my access to education. So I think I formed quite early a conviction that I had a voice when others didn't, and that I should use that voice for them. And as I grew up and grew older, I came to the realization that it's the lawyers who really make things happen in international politics and have the ability to impact people's conditions in reality. And it struck me that perhaps with the naivety of youth, that the sort of rebellion against the state and state power and state excesses, it was important to be the advocate who stood up to that and represented the individual. And I think it's interesting that people understand that at the domestic level very easily. That's the role of a human rights lawyer. But when you take it to the international level, there's this presumption that people are guilty and that they are somehow not entitled to the same protections. And I strongly dispute that. And I think it's most pressing to ensure that the most maligned individuals in the world are afforded the same basic protections as everyone else. We're aspiring to apply the highest standards of legal practice. And if we don't do that, then we're no better than failing states or pernicious states. And while it can be personally challenging to work with the material and the charges that are faced at the international level and the subject matter, it's extremely interesting to get down at that level and to see the human in the defendant and to make sure that the prosecution is held to account and does its job properly, and ultimately contribute to the whole endeavour of the project, which is to secure, where appropriate, proper convictions that are sustainable. And that's an important role for the defence to play, either in ensuring that the right people are acquitted or people are appropriately convicted.
So since the very beginnings of the project and field of international criminal law, and perhaps in particular since its quote-unquote rebirth in the 1990s, there's been this so-called battle for an equality of arms between defense counsel and prosecution. Where do those efforts stand today in your view?
Well, the resourcing that's required to conduct a proper prosecution investigation is enormous. I think, as I've explained previously, I think that it is possible to conduct a proper defense investigation with a smaller team. So I don't think that the resourcing necessarily has to be equal, and that's not feasible. But the prosecution plays a role in, I think, ought to play a role in assisting the defense in access to state authorities and this sort of thing. I think it's laughable that there's any real equality of arms, given the office that the prosecution enjoys. That said, I don't think that. My experience has been that small, well-equipped and skilled teams can combat all of the issues raised in an international trial. So it doesn't necessarily need to be resource intensive, but I certainly think that the resourcing available to the defense under the legal aid package at the ICC is inadequate. And as a consequence of that, you can't attract the lawyers who will have the skill and ability to refine and the confidence to refine the issues such that ultimately the court would make a saving in time and resources. So I think that there's a stark imbalance that leads to inefficiencies, and that the international community would do well to really combat that by properly investing in the defense.
You've already mentioned this actually in your answers, that in some ways defense counsel are well understood in domestic law as playing an indispensable role in protecting the rights of the accused and so on and so forth. But that doesn't really translate as well to international criminal law. Instead, what we often see is misperceptions of defense counsel as defending, quote unquote monsters, and doing something which they should not do, which is defending these people who are accused of committing awful atrocities. How do you combat that misperception?
Well, it's my professional obligation is to ensure fundamentally that the proceedings are conducted fairly. And that contributes to the role of the court, the ultimate goal of the court being to determine the truth and what happened and who's responsible. And so part of the role, I think, fundamentally is holding the prosecution to account, scrutinizing, subjecting the prosecution's evidence and, in probably most importantly, its witness testimony to proper scrutiny. And in that way, we assist the court. It is not defending somebody by arguing by hook or by crook that they are innocent. We have no burden to prove that. It's the prosecution's burden to prove beyond reasonable doubt that what they assert happened. Equating defense counsel with the actions of their clients is manifestly wrong. And my professional duty is to ensure that their fundamental right to a fair trial is upheld, and without that, then any conviction would be completely insecure and wouldn't be sustainable. So if they're acquitted, then that means that there was a flaw in the process, and that fault for that would lie with another party, i.e. the prosecution, and that would be the right outcome. If they're convicted, then my hope would be that they're convicted for the right things and ascribe appropriate levels of responsibility. I think it's also important to remember that defense counsel bear the burden of advising their clients, and that advice can be very robust. And if the evidence is overwhelming and the charges are appropriately drawn, then my professional obligation is to advise them to plead guilty, which we do. I've never had that experience at the international level because these cases are complicated, and very serious legal issues arise in all of the cases that do need to be examined by the judges. The other feature I think that is important for people to understand is that our clients may be very psychologically damaged, and it's our responsibility to handle them in that state, but that can pose challenges for us in actually conducting the defense. It is then our role to, in scrutinizing the prosecution's evidence, cross-examine people who've suffered unimaginable trauma. And I see it as my professional duty to do that properly, to exercise the skill and the experience that I've obtained over the course of my career, and worked very hard to meet the highest standards I can, to exercise that skill to ensure that the evidences and the witnesses are properly, appropriately and fairly scrutinized without causing further harm. And it is a rare skill set that means that I feel duty bound to exercise it, even though it's not a pleasant experience. Just one thing I would add is that one of the great pleasures, I think, that I've found in the course of acting as defense counsel is seeing the human in everybody, no matter how monstrous they might be perceived to be by the general public.
Thank you once again, Kirsty, for your answers, for being here with us, and for all of your contributions to the events that we're having here in Nairobi, Kenya. Thank you very much.